Is defense counsel ineffective for failing to request a cross-racial identification charge in an identification case? To find out, you have to read People versus Watkins, but it's 48 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People versus Watkins. The citation for this case is 2024 New York Slip Opinion 02842, published by the Court of Appeals on May 23rd of 2024. The issue in this case is whether it's ineffective assistance of counsel for a defense counsel to fail to request a cross-racial identification charge in an appropriate case involving identification. The background that I think is helpful to understand this case is two things. First, what ineffective assistance of counsel is. The Sixth Amendment to the United States Constitution guarantees defendants the right to be represented by counsel, and that includes inherently a right to effective assistance of counsel. Not just a lawyer, but a lawyer that's effective. There's two different tests. There's a federal test and a state test of New York. The federal test is called the Strickland test. It's a two-part test to determine whether counsel has been ineffective for the purposes of ineffective assistance of counsel, which is essentially a Sixth Amendment violation. The test is part one, that the lawyer's conduct fell below an objective standard of reasonableness. And number two, that there's a reasonable probability that but for that error, there would have been a different outcome. That's the federal standard. The New York standard is a little more protective. They say it's the Baldi standard, B-A-L-D-I. And that standard says, reviewing the totality of the circumstances, the law, the evidence in the case, in a particular case, must show that the lawyer provided meaningful representation. If the representation was not meaningful, then it's ineffective assistance of counsel. So it doesn't have that but for element where the outcome would have been different. That's not part of the New York standard. The other thing you have to know is that there's a case called Boone that was from New York Court of Appeals, where basically the Court of Appeals said that with respect to a cross-racial identification charge, if it's requested, the court must give it. If it's requested, the court must give it if there's an identification case. Okay. So what are the facts in this case? The facts are that in October of 2016, the victim in this case, named David Pena, was approached by a stranger on the street and struck in the left cheek with a hard object, maybe a piece of concrete. It fractured the victim's orbital bone. The victim was not looking at the assailant, the attacker, when it happened, but he ran into a nearby basement, grabbed a stick to protect himself, and came back to the sidewalk. At that point, he observed the attacker's face for a few seconds until the attacker turned around and walked away. Pena reported the incident to the police 3 days later. He described the attacker as a black man not much taller than himself, wearing a black or brown pants, white t-shirt, tennis shoes, and a hoodie. The police showed Pena 462 mugshots from a book, none of which depicted the defendant. Could have been from the computer. But they showed him 462 mugshots, none of which showed the defendant, and Pena never identified anyone in that mugshot showing. 2 days later, Pena called 911 and said that he saw the individual who attacked him on the street. The police stopped the man matching the description, but Pena said it was not the right guy. It was not the person who attacked him. The next day, Pena again called the police and said he saw him on the street right now. When the police arrived, Pena pointed out the defendant and said that was the person who attacked him. The police arrested him, and that's the only evidence. The only evidence identifying the defendant was Pena's testimony. So it was testimony of Pena who identified the defendant as the person who attacked him and the person who he observed on the street. There was surveillance photo capturing part of the incident, but it was too blurry to identify the features of the assailant. The defense's position in this case was that Pena was honestly mistaken, that it was an honest but mistaken identification of the defendant. At the end of the case, the defense counsel sought a one-witness identification charge, which basically is a charge to the jury that in one-witness cases, it's even more, there's sort of like a lot of protections in a one-witness identification case. And the court gave the one-witness identification charge, but the defense never asked for a cross-racial ID charge, which basically says that there's a cross-racial identification effect where it's more difficult for a person of one racial group to identify. It may be more difficult for a victim in one racial identification group to identify accurately the perpetrator of another identification group, another racial identification group. He never requested it, and so the judge never gave it. The defendant was convicted. The defendant appealed. claiming he was deprived of the effective assistance of counsel, Sixth Amendment violation, for the failure to request that cross-racial ID charge. The appellate division affirmed the convictions, finding that he received meaningful representation. It complied with the Baldy and the Strickland standards, and it appeals to the Court of Appeals. And they review. This is actually a long decision. There's a majority opinion, there's a concurrence, there's two dissents, or there's at least one dissent. The issue on this appeal is whether that single issue, whether that single alleged violation, the failure of defense counsel to request that cross-racial ID charge, was ineffective assistance of counsel. Now, Boone doesn't answer it. That case I talked about earlier. Boone says that if requested, the court must give the charge. But it doesn't say that the lawyer is ineffective for failing to request the charge. And the answer in this case is whether it's ineffective assistance of counsel. It is not. It is not. Why? Because at the time, it was not mandatory to give. And this is not the kind of clear-cut and completely dispositive defense for purposes of single error ineffective assistance of counsel claim. There could have been a strategic reason, perhaps, why counsel did not request that charge. Maybe he thought it would have offended the jury. Maybe they would have highlighted something that the counsel did not want to highlight. There's no clear entitlement to that charge when this case was tried in 2017, and therefore it was not ineffective assistance of counsel. And that's the case of People versus Watkins. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.